All right, so you've got the LLC, you've got the domain, maybe you've even got contracts, and you're looking at your legal setup wondering, what exactly am I protecting? I'm just doing all these things because somebody told me I should. The answer is in the zones. Today, I'm going to map 4 of them for you and exactly how Brasília was built. By the end of this, you're going to know exactly what you're protecting in each zone and which one you need to be more concerned about. I'm Samantha, the traveling trademark lawyer, and this is the Brasília Blueprint, episode 2. Let's zone in. So, we're here in Brasília because Brazil is one of the only cities on Earth that can make this point visually. Lucio Costa, he divided the city into 4 zones when he designed this whole structure because there was no city to naturally build around. He created Monumental for power, which is what we're in like a divot of right now. The Gregarious for the commerce, for buying stuff, doing things. Residential for the housing, and then green space to exist and make things nice and pleasant, and ideally a bit more shade in the square he could have thought about too. But it's not a chaotic sprawl. It's coherent, it's planned, it's literally a work of art according to UNESCO, one that nobody's allowed to mess with anymore. If you don't zone your IP in the right buckets, in the right way, in the right space, you get chaos. When you do, it gives everything else a job. So, in the next 10 minutes, I promise, you're going to know what a trademark protects, what a copyright protects, and what a patent protects, and you'll stop wasting money, time, Google searches on trying to figure out the protection that doesn't actually match what you care about. First, we're going to continue here in the Monumental zone, where identity and authority live together. Zone 1 is the monumental scale. That's kind of where we are now, right? Or a part of it, at least. This is the Esplanada, this big, long green strip going up and down the city. It's full of these giant federal buildings, and a ton of them, right? You can look around here, and just from what I can see, there's 1, 2, 3, 4, 5, 6, 7, 8, like 10, just here. There's annexes behind here that we can't even see. It's kind of ridiculous, actually. This zone, this whole point, it's about power. It's about visibility. It tells the market who's in charge. Sounds like a trademark to me, because a trademark protects your brand identity. Who's in charge of selling the thing that you sell? Doesn't matter if it's a service or a product or, I don't know, NFTs. It's your name, your logo, your slogan, anything that signals to the market that this came from me. Not what you made exactly, but who made it. It's very clear who made this. When you file a federal trademark with the USPTO, you get the right to use that trademark, that brand, nationally. And it's fitting that we're in the center of national politics in Brazil. You get the right to stop others from using anything that could confuse someone else into thinking it was something similar to you. Not just identical, but confusingly similar. If I could possibly think they were related to you and your brand and what you're selling, that is enough for us to be able to shut them down, if it's similar enough to mislead the market. So here's what that looks like in real money. If you sell on Amazon, a registered trademark literally unlocks what they call the brand registry. That means you can take down counterfeit listings. You can get enhanced pages. You get a direct line to enforcement when somebody does copy your stuff, because if you're big enough, it's going to happen without waiting months for Amazon support to get back to you. With a registered trademark, platforms have a legal obligation to act on your behalf. That's the difference between you filing a complaint, sending it into the void, and praying the gods of whatever platform you're operating on respond to you. You have a right. And one more thing about this zone, it is entirely territorial. You can't just like show up here because you want to. A US federal trademark protects you in the US. That's it. International sellers, we'll talk about how to expand that later. That's a whole different map. It's not this one. You can have trademark rights without registering on this big, grand public scale. They're much harder to defend unless you show up with the plan, with the napkin, with the scale that you're operating on. But those rights that show up without you registering, they're called common law rights. They're narrow. They're limited to where you operate, right? It's not going to go past your state line, likely. They're a nightmare to enforce. They're very expensive to enforce. You have to wind up in a courtroom, basically. Federal registration is your monument to the zone, so when somebody shows up and they see a building that tall, by the way, it's the tallest in the city, because they wanted a physical reminder of the fact that Congress, the representatives of the people, are the most important things in this city. When you have something that loud, that screams your name, like a federal registration, you can actually shut people down without winding up in a courtroom and having to fight over every little bit of it. So, before we leave the monumental zone, there is one more thing that lives here. Most founders aren't even really aware it exists in a business sense, but they see it every day. It's called trade dress. Trade dress is actually part of Trademark. It's not about your name, it's more about how your brand looks and feels. The total commercial image of when people are buying your stuff. What does this look like in reality for most brands? For some brands, it could look like your signature color, the Louis Vuitton red or Tiffany's blue. It could mean, if you have a very unique layout for your website, the layout of your website. If you're Coca-Cola, the shape of your packaging. The fact that I don't even have to describe that bottle to you and you can already picture it in your mind's eye tells you how strong this needs to be able to get trade dress protection. The vibe of your physical space, to a point. There's some fights about influencers and their vibes on design lately. Tiffany's doesn't just own the word Tiffany as a trademark, they also own that specific shade of blue. It's actually called Pantone 1837. It's 1837 because that's when Tiffany's started, and Pantone decided to give them that year as a nod to them in their own naming. It's federally registered trade dress, both the name and the color. Louis Vuitton doesn't just own the name Louis Vuitton, they own the red sole, or they tried to. Anyway, if somebody else puts a red sole on a stiletto, Louis Vuitton tried to make them not be able to do that. They wanted to have legal standing to act. When you're the only one and it's clear from something in the structure of what it is that you sell that it's clearly yours, then we start talking about this additional protection, trade dress. So what I've been hinting at already is, here's the rule. Trade dress is protectable when it's unique enough. When it's unique enough is when the market, when a huge chunk of consumers identify that thing, that shape, that color, that smell, that packaging as coming only from you. Likely, you worked with a factory in China or Taiwan to make it specifically for you, and it's not purely functional. There's a way that it identifies what you're selling. Because if it's purely functional, then we're not going to allow you to be the only one to use that. You can't trademark the color red on a fire extinguisher. That color is doing a job because people are used to that color showing them where they can find a fire extinguisher. Tiffany blue is doing nothing for Tiffany's selling jewelry except saying, this is us. That little blue box is quoted again and again and again in movies, media. That's protectable. Trade dress also lives in this whole monumental zone because it's just as loud and demanding to the market as any monument that I could build to claim something to the public. It's about who you are to the market, just expressed through aesthetics instead of a name. For online brands and service businesses, if someone can identify your brand before they read a single word, that's potentially trade dress. Now you know that it exists. I want you to build this zone intentionally. Understand the overlap of the monuments you can build to the public to show what your brand is and have them know it's you before you ever open your mouth. Quick note, just to pause this, if you want the full blueprint in your inbox and each episode in order outside of YouTube, join the Blueprint Dispatch below. I will email you the links to each episode as they drop for free. The link is right there. Or you can subscribe to this channel and just turn on the notifications when the things come through. Whichever you like, your choice. So, copyright covers the creative expression. What on earth does that mean? It means for some businesses, like in this commercial, literally the thing that they sell. If you're a course creator, that means your workbooks, your content, everything you put out. For others, it might be the stuff that you're putting on social media to sell something that is not the creative expression of your copyright. The second you create it, the second somebody can listen to it, watch it, look at it, your art, your podcast, your YouTube video is immediately yours. You already own the copyright. You don't have to register it to own it, but registration does matter for enforcement. We'll get to that in another video. This is the commercial sector. It's literally the mall. It's where the city's daily life plays out. Between the monuments, over on the other side over there, and the neighborhoods to the left and the right. Brasília, mall life is popular. People gather here in the shopping centers, the restaurants, the cultural venues. It's all right here. This is where Brasília's life tends to happen. Not the government buildings that are gorgeous on the other side of me, but the spaces in between. For your intellectual property, what on earth does this mean? This zone doesn't introduce a new type of protection. This is the zone where your protection, or lack thereof, gets tested in public. Again, this is the Gregarious zone. And something I really got to stress here is that intellectual property, it's not passive. You have to keep watching what competitors are doing. You have to tell them to stop using your stuff if they are. Otherwise, it dilutes your brand. It makes people think that you're doing other things that you're not. It requires that you made the right decisions back in the other zones for copyright, trademark, and trade dress that are all around me. And behind me, part of the reason we're here is this is such a perfect example. You have a lot of local brands. Every Brazilian knows the brands that are here behind me, but a lot of these are quite global, or if not regional. You've got Farm Rio, which is a clothing brand that makes very cute printed stuff printed prints. Very cute tropical printed clothing. They've started expanding into the US, and the quality of what they make is quite high. Now, Firm Rio can try to protect the print design themselves with copyright and prevent somebody else from doing the exact same thing. That's tough to enforce in a world of fast fashion. But people will happily spend a lot more money on Farm Rio stuff because they know the quality is better because that brand name is protected and nobody can use that. When you combine these two together, it makes it really easy to shut people down. You've got Coca-Cola and the famous Coca-Cola Santa, right? That image as it is protected by copyright. Pepsi cannot they can put a Santa, but they can't put that Santa. That like old school, old-timey Santa in that way. Outback's also here. I don't know why they expanded to Brazil. It's not great. Those things are names or identifiers of what they sell that nobody can take away from them. And they do all of this before the market puts pressure on them because it's so much easier to handle this if you have the right protections in place beforehand. I want you to ask yourself now, are you building something that you're willing to defend? Because if the answer is yes, I think you already know where to start. This is scale 4, the Bucolic zone. As strange as that word sounds, it just means for leisure activity. In Brasília, this is the green space, the parks, the open land, the breathing room, and in IP, patents exist in their own protected ecosystem. That's exactly what this is. It's separate from everything else that we've mapped today. You're not allowed to build anything here. This is purely for people to walk, enjoy the greenery. I know they have jazz festivals here. It's really nice, actually. Patent is designed to protect a novel invention, a new process, a new material, something that didn't exist before you made it. So let me give you an example. Not too far from here, like 1 kilometer up the road, there was an artist named Gisela Colon. She built these extraordinary towers of light. They were these shimmering, glowing structures. And the design itself was very simple. They were just, I don't know how to, I can't. They looked like, I don't know that I can say that on YouTube, we'll get flagged. They looked like adult toys. Super phallic, very phallic, but glittery, like glittery adult toys. Dear God. So she kept replicating this same shape again and again and again with different colors, but the material itself that she developed to build them, she invented the compound. Nobody had ever made that substance or that process before her. That, not knowing more details about it, is theoretically patentable. The material itself. But the towers, that repeating symbol over and over again, becomes, because it's art somebody can deal with, it's copyright. So we sometimes have this overlap in what patents protect and what copyright can protect. Here we have a bit of an overlap. We have a museum stuck in the middle of the Bucolic area. Patents protect the invention underneath the thing, and that's what's important to understand. For most service providers, coaches, brand builders, you don't need a patent. Patents are, 1, expensive. They are tens of thousands of dollars regularly in attorney's fees, much more expensive to file. They do expire. A trademark never does if you're still using it. They have a 20-year limit on the utility patent, 15 for design. What you're buying with a patent is a limited time monopoly on your invention. After that, it becomes kind of public domain and anybody can do with it what they wish. Think about the medicine that your doctor came up with that's new and revolutionary. Eventually, there's a generic of it. That's what a patent is. Most people watching this series are not going to need a patent. Your zone is going to be trademark and copyright, and maybe trade dress if you're selling some stuff. Build there first. Think about what's most important to you first. But if you ever create something truly novel, a new process, you make shimmery adult toys that are bigger than buildings, proprietary system, a material that didn't exist before you ever made it, that zone is here. And ask me for a referral, I'll tell you where to go. That is not my lane and we were staying out of it. So back to our scales, right? We've got the Monumental scale, this dark green that runs along the entire length of the city. That's your trademark plus trade dress. It protects who you are to the market, to everyone who's buying from you. That public-facing monument that you present to the world. And then we have the residential scale. Remember this one? Copyright. That's all of this yellow stuff where everybody gets to live. It protects what you create because that's what you do at home. Your content, your course, your creative work, your ads, your website, your book full of recipes. This creative work, that's what gets protected there. Personal, automatic, by the way, the second someone else can engage with it, intimate. And then we have the Gregarious scale, right? The black lines in between where everybody's doing business. This is where your IP actually gets tested. It's not a protection type, it's the enforcement reality. Because the market itself doesn't care what you filed. It only responds when you're willing to defend, whether that be through a mass of very loyal followers or using the court system itself. And then remember the Bucolic scale, the patent. It prevents what you've invented. All of this green, all of this magical stuff. There's a lot of it. This is expensive to maintain. maintain, expansive, and very niche. Most business owners are trying to live in the wrong zone. They file an LLC and they think that they've built a whole city when they haven't even broken ground on the playground at the park for the kids. We want to make sure that you're using the right protections in the right scale, in the right sector, so you get the protection you want and that you think you already have. You need to understand that Brasília's zones are literally protected by UNESCO at this point. You cannot change the fundamental architecture or design of this city. You can't change the outside of any buildings. It's like working in a historic district. It's just not possible anymore. Theoretically, all of this area here along the lake is supposed to be protected, and it's supposed to always be publicly accessible. None of this is allowed to be privately owned until you had a bunch of rich guys that decided to build giant mansions literally on the waterfront. Fortunately, Brazil had enough pressure that they were able to force people to literally pick up their houses and move them back so the lakefront became public again. The power of enforcement, this is what's really important because the market doesn't respond to your rights. The market responds to being forced to change them and respect your rights. You also have people mixing up things. Some people think that having their LLC, it means they have a trademark or that a copyright registration can protect their brand name. Wrong scale, wrong zone, right idea. You know what else really bugs me? There's another one. Oscar Niemeyer. We haven't said that name a lot in this series yet, but he's the guy who designed all the buildings here while Lucia Costa designed the whole structure that we're looking at. Him and Costa worked hand in hand and he violated the rules himself. He built this giant attorney general office over in one of the leisure zones. Massive building, super tall. It does look really cool, but it's not supposed to be there. Almost 40 stories tall in what's supposed to be a very low density zone. Nothing's supposed to be very tall. You're not supposed to screw with the line of sight here. Everything's supposed to kind of slope down towards the lake. It's his system. He broke his own rules. So it's not a perfect system. And the reality is it's never going to function exactly how you want it to. But it's a little bit about what Brasília taught me. Making your own rules, bending or breaking your own rules as well. Let's talk really quickly about some myths. You might be thinking, well, I have an LLC, so I own the name. An LLC is for taxes and separating your personal assets from your business assets. It gives you 0 nationwide trademark rights. You can also think maybe you bought the domain name. I already bought the website, so I'm protected. Well, somebody else can buy the domain name of your exact domain name .net, and unless you own the trademark, you've got no way to ask the domain host to shut it down. You might also think, myth number 3, I copyrighted my business name. It's not a thing. We copyright for artists, we trademark for business names, for brands, for logos. Myth number 4, I posted it first, so it's mine. Posting online gives you really fragile rights, most likely subject to whatever platform you posted it on. If any, the federal protections of the trademark or the copyright office are going to be what protect you if someone reposts your thing or you have a phrase go viral. That's what we're looking for if you're trying to monetize and commercialize an idea. Myth number 5, and last one for now, because oof. You might think, oh, I put that little circle TM on my logo, so it's totally registered. Anybody can use the little circle TM. It's the little R in the circle after the name that you can't use. You can only use that after you have a federal registration, not even just the application. So again, wrong zone means we probably got to tear your hotel down. Now you know your zones. And next episode is where we're going to talk about before you file anything, because we need to talk about timing. When does it actually make sense to file a trademark? And what do you need to have in place before you really even want to talk to somebody about it? Hint, the answer is not a lot, depending on how you want to go about this. What you do need to know, and part of the reason we're here in Villa Planalto, is that filing early is just as costly as filing too late sometimes, depending on your situation. Episode 3 is going to be the filing timeline. And the quiz is below. It'll tell you in 15 minutes if a trademark makes sense for your business and if your business has a trademarkable brand that the U.S. Patent and Trademark Office actually wants to trademark. The blueprint dispatch is also below if you want to get episode 3 in your inbox. Let's go build your blueprint together and then take a trip back and see more of Villa Planalto.